Dear colleagues, good afternoon. We are glad to see you on our event, which we conduct within the framework of Ukrainian Week of International Criminal Justice, conducted by the Center of Civil Liberties, which has a very good reputation, and this event is connected more than 10 years, and we are discussing the processes which are necessary for integration of Ukraine and all other processes which became necessary due to Russian aggression against Ukraine. It is based on legislative initiatives, investigation, and other criminal procedural aspects which need harmonization with the whole world, with international practice. And actually the results of this integration have to be to look have the look of the fairness, and Ukrainian society really seeks for fairness. Today we are going to discuss legislative aspects. We have good news. We have preliminary context, and we have some details which we would like to share with you and to discuss with you. First of all, let me introduce myself. I'm Alexandra Romantsova, and I'm the Executive Director of the Center for Civil Liberties, and I will be moderating today, and I will be happy to give the words to our wonderful speakers. Stanislav Petrenko, the head of the department War Department of Prosecutors General, and also he is the secretary of Interagency Working Group, whose results we are going to discuss actively today. Alina Pavluk, the coordinator of work of legal advisory groups, and Mykola Pashkovsky, the senior scientific advisor who specializes in learning, studying international crimes, and he is the member of international group of harmonization of international legislation. And also Konstantin Zadoev, he is the professor of the National University of Shevchenko University, Faculty of Law, and one of the fathers and founders of the Week of Criminal Justice of Ukraine, and the person who has been in the process of internal harmonization of criminal and procedural aspects and international aspects. And so our main task today is to discuss in simple words how Ukraine should prepare to punish international crimes and for international crimes which happened on our land and with our citizens and with all people, which happened to people who had been here during the last 12 years. And we are going to discuss the process of harmonization of Criminal Code of Ukraine. This process started in 2016, and we can speak about 10 years. And we have been developing different bills, and today we have good news. In January 2025, with the help of the initiative of Prosecutor's General Office, we have created the International Working Group, Interagency Working Group, which gave opportunity to provide proper investigation with the help of proper legislation, which would let punish those who conducted crimes on the territory of Ukraine. And despite the fact that we work with ICC and with the Tribunal against the aggression of Russian Federation, our main message of the process and the punishment on bringing into responsibility of those who have committed crime will be put on Ukraine. And this is is a unique and very big scope of tasks. And if we ask for assistance and include international jurisdiction, still it remains our tasks. So this working group, the aim of this working group was to create a certain legislation. It had to create active instruments, active tools, and include the experience of the work of the prosecutors, and including embracing war crimes, potential elements of genocide, and crimes against humanity. Of course, it will be the basis for further work against the crime of aggression, because basing on the case of Ukraine, Russia will be making international practice. So this was my entry point. These were my entry points. Now I give the word to Stanislav Petrenko, who will start directly with presentation and the development of international group. One technical issue: is the translation okay? Should I speak? So the tempo is okay, the pace is okay. Good. Thank you very much, Alexandra. And thank you, the Center of Civil Liberties, for organizing this week and for organizing this presentation, because the issue of counteracting of international crimes and bringing potential changes into legislation is of high importance. And it's very important that civil society serves as an expert support and as a bridge for, and we cannot imagine a better site for bringing such ideas into the world for their further implementation and for their further analysis. I have the opportunity to represent the work of our group, and the essence of the result is the development of the bill, of the draft of law as to criminal code and criminal code procedure and Ukraine regarding harmonization with the Rome Statute. And where are we now? Because it is not the first attempt, but now in 2026, a lot of things changed. First of all, after the ratification of the Roman Statute in 2024, certain changes were brought into our criminal legislation. Now we can say that all international crimes within the framework of Roman Statute are embraced in Ukrainian legislation. We can speak about war crimes, crimes against humanity, genocide. The provision of genocide was corrected basing on the Roman statute, but war crimes and crimes of aggression haven't been changed. And these are the two types of crimes which are the main scope of crimes conducted by the Russians against Ukrainians. If you speak about war crimes, it's more than 2,400 crimes conducted by Russia against Ukraine. So this issue is still relevant, and we have to do something about it. Actually, what are the problems we want to resolve and what we are facing with? First of all, we are focusing on the key moments. War crimes, according to the Article 448, are formed in general way due to the blanket form. This is violation of customs of war. But these violations of breaches of customs of war embrace more than 30 war crimes. You can see it on the slide, which are absolutely different, starting from illegal deprivation of law and intentional attack on civil population. So on the legal system, on the national level, which conducts criminal prosecution, and finally the court have to use academic and analytical literature and address to international law, and to provide effective prosecution, and to identify these crimes correctly, because these norms are not enough. Speaking about aggression, the situation is also difficult, because Article 438 is basing on approach of the Nuremberg process, and of course this Article 438 of the Roman Statute and the creation of the Special Tribunal for the aggression, to analyze the aggression of Ukraine, went further, because some articles really lack full definition. So we had to improve this within the framework of our Interagency Working Group. This Interagency Working Group was founded with the initiative of the Office of President of Ukraine, with the support of Prosecutors General of Ukraine. And on one hand, we had the support of representatives of the state, on the other hand, representatives of international organizations and civil society organizations. Of course, it's impossible to create a very big focus group which would embrace hundreds of people, but we were able to create a group of experts which helped us to make a document within a year. And now we have certain achievements when we have expert panel discussions and certain results. Coming back to the contents and what we were talking about. Uh, so if you speak about war crimes, the proposal is not new, and it's based on the transition to the catalog of war crimes, to the enumeration of constituents of war crimes basing on the Roman statute. And during the discussion and basing on the previous experience, we came to a conclusion that we should separate, we should have 5 articles as to the main object, and here we speak about war crimes against the personality, appearance, property, and also against cultural heritage, and war crimes based on used prohibited substances. We believe it is very rational. We don't want to create additional articles, but such division, such subdivision is corresponds to the Ukrainian criminal code, and certain deeds should be bounded to this object. And we believe that such solution can be based on our internal and international experience. The given catalog gives us opportunity to embrace all articles of the Roman Statute. Article 8 is a universal point how to define war crimes in a civilized world. In each part of the article, we speak and we define certain certain crimes like intentful killing and intentful deprivation of will. So we release blanketness. So it is defined legally, it can be qualified legally, and it can be justified. Huge work was done speaking about the contents of the war crimes and how to adopt them into our legal tradition, and also how to translate them unilaterally and how to adopt the translation, because it turned out to be a difficult task. The language of international agreements is different from the language of criminal code of Ukraine, and the process of adaptation in order to preserve the contents and to translate properly was rather difficult, and we put a lot of effort to improve the text. And also within the catalog, we take into account the differentiation of punishment for war crimes. It's not a secret that a differentiation, a definition of punishment is not perfect. We have Part 1 of Article 438, which embraces the most number of crimes, and also the qualified content of crime, for example, a deed which caused the death of a person. And of course, we are trying to preserve a person's life as the most valuable thing. But if you speak about cases of torturing of military service personnel, we should say not about 12 years of imprisonment for that, because it is a crime against humanity. And also here we propose the definition of aggression, which agrees with uh, the Roman statute, and also it speaks about the necessity of special tribunal, and also the definition of the subject of the crime of aggression, which has to be regulated by the law and by the chamber of the court, of the international court. And also the regulation basing on legislation is more effective. And if you speak about the crime of aggression, it corresponds to the requirements of international law and takes into consideration the legal position of the chamber of the Supreme Court, and also for Ukrainians, it is important that it takes into account a long-lasting aggression of the Russian Federation, which started from 2014, and takes into consideration the challenges we faced with in 2014, not only in 2022. And it here we speak about the necessity of provision of criminal prosecution on the international level. The subject of crime, according to international project, is defined in the way how the Chamber of the Supreme Court proposed. And this definition is a little bit wider than it is defined in the Article 8 bis of the Roman statute. It can be explained by the fact that the prosecution is limited by the jurisdiction, but our prosecuting bodies have certain obligation in front of people of Ukraine to prosecute the crime of Russia against the people of Ukraine. It means that the jurisdiction of national legislative bodies has to be preserved proportionally to the scope of aggression. It means that at least we should embrace 10 high-ranking people of the Russian Federation, but also more people. And it also shows that the criminal legislation has to be effective both on international level and on national level. We cannot make responsible people or just on national level, and our people showed that they are able to make the prosecution possible on national level. And also we propose to regulate some parameters. First of all, the changes to the above mentioned articles do not lead to criminalization and do not propose any so we must speak here about a full absence of decriminalization in order to avoid any doubts, manipulations, and speculation. So it has to be written by the law. Also, we propose to speak about the authority of prosecutors, and mm, this will, thus we are speaking about optimization of the process of criminal investigation, and about investigative jurisdiction. And it's not a secret that currently not only security service of Ukraine but also police force of Ukraine provide investigation and send these cases to court, and we believe that this practice should be put into procedural legislation. And
So, talking about such approach, which was offered in the bill, allows us to gain such results. Indeed, we align our legislation with international law in case of receiving this bill. We can say that harmonization process is over. It's difficult to say if it's 400%, but at least its main part, like for 99%, will be fulfilled. Of course, it will improve the quality of this law, and it will be more clear. The person will be suspected, not just some abstract violation, but in specified crime. It will show us that the law will be more clear, more understandable, and it will be more clarified in different cases of crime for those who do the investigation, talking about national or international people who do the analysis. Will understand better, have better understanding on crimes, and it will influence on keeping to the rights for defense. Talking about a future procedural process, talking about European human rights, which will assess the law and specify violation. And we have to coordinate the language, the terms of communication, as it has been mentioned before. We can talk about the translation, but believe me, a lot of resources, a lot of difficult situations were because of translation when the international law was translated, and the results were so strange and bizarre that it even had deeper discussions. So that's why it's important to have a common language with the international community. Of course, it improves the practices, and talking about the criminal prosecution for international crimes. So to sum up, so the bill has been developed and by the general prosecutor sent to the cabinet of and office of president. As for now, we hope for political support. We are open for future discussions with the representatives of civil society in order this bill could be improved, as there is always something what can be improved and refined. But we believe that the process of harmonization has to be over, as it was mentioned by Ms. Alexandra. It's a long way but we want to hope that we have hope that this process will reach its aim. Thank you. Thank you very much for conversation, for using like simple language. It's very important. It's clear when you talked about changes and how they should impact the improvement of process. And I don't know how much pressure we can put on physical aggressor who committed the crimes, but it's important that we need to remember that justice is not just about punishment of those who are aggressors, but it's essential to renovate the rights of victims and those who survived. When we talk about justice, sometimes we are told that we will never see these criminals, that they will be killed at front line or they will be far in the Russian Federation. But still, this bill gives possibility to understand what kind of victim we have become using international language. Now I would like to invite Alina. It's a very important process of dialogue in the framework of interagency group. I would kindly ask you to talk about those aspects which you would like to highlight and talk about the role of public society. Thank you for invitation and possibility to share my vision and experience. As it was mentioned at the beginning, the whole process and work, in particular of this working group and the results, it's a long way, starting with 2014. And I really want to think that now at this stage, this phase, we don't need to talk about the request for changes in the law because it has been formed a long time ago. And I would like to pay attention that in this context, it's important to remember the vision of victims of war. Because for each of victim, it's important to understand what happened, what crimes the person had gone through, and the system of justice could see those facts which they are in reality. And what Stanislaw mentioned, that in this context, the bill has to clarify and make it more understandable the changes in this category of crimes. The word which has been mentioned many times in today's conversation, it's a consolidation. And indeed, the work of the very working group, which has become a consolidation of efforts as on national level and international practices and experts. But I also would like to add, that it's important to listen to those who deal with practice. And we have come such a long way in order to receive this text. There were some moments which showed the position of national system of justice in 2019. When the work on harmonization started, there was one of the efforts to represent the bill which could change the criminal code of Ukraine, and talking about requests from the national system that we needed it right now. It was very important. We needed to make it systematic, our experience, talking about crimes in crime and the occupied areas. In 2024, everyone expected that process to be over. We could work more effectively, change progress. But unfortunately, we have what we have. After the full invasion in 2022, we had understanding that those changes were needed back then, but we still don't have them. It doesn't mean that we have to stop, and it's not important. No, vice versa, the quicker decisions will be made and changes will be made in the law, the sooner we'll have understanding and better stability of our practices. Also, based of work of interagency working group, they covered international experts, because after 2022 we saw big efforts of international community in order to support Ukraine, and in some moments those initiatives were not very good for national practice and how it works here, and the very process which we have come through on this document development has shown how the communication works, involving different stakeholders into discussions, and in order to have such kind of result. And one more important moment, talking about consolidation, that all results, outcomes that the representative of national society had since 2014, they were included, were heard. That's why I want to support of what has been already done. Also, shortly, a few more minutes, I would like to highlight, talking about the changes, proposed changes. One of key is the action and timeline, talking about the absence of decriminalization of provisions. It's one of key moments which we have seen in practice, that it has a big impact on understanding of crime, its perception, as the discussion on which will have its force with the time, with proposals on how to work with the law qualification and the initiatives to the law. But as it took a long time, it had to involve the crimes against humanity, and not receiving this this clarity that it has to be spread according to the norms of international law. It created the additional challenge in order how to stand with this legal position, which were committed only after October 2024, and those crimes against humanity, how they looked after 2014, and what for qualification they had to be referred to. So that provision was also included. And talking about investigative jurisdiction, the very procedural code is very important of changes how the system works, and talking about the scale of crimes which have been registered. This question is not just about clarity in law, but also about human resources which was involved in the investigation. We know that as this code looks at the as the service, security service, which has its permission, and after that full invasion, we can see that different investigators were involved. We can see that law enforcement agencies were the first subject of reaction, who go to the site of crime, who register those crimes. So the procedural decision to add the investigative jurisdiction, identify the pre-trial agency, it's that kind of step which will help to get rid of some procedural limitations and save time to collect, in order to collect proofs, and help also to react faster. And Also, I would like to add that all proposals and decisions are very important, and we hope not to wait 10 more years in order to receive results on this law. But at the same time, we shouldn't forget that the question on harmonization to the changes of criminal code is that needed part of changes on the background of important questions and problems which need reaction, and we would like to make it a successful case of reaction and response to make it the next step on the level of state to have one consolidated approach and common vision and how to support the national system of justice, which could be implemented in the united policy concerning the consequences of aggression. Thank you. Now I would like to invite Paula to take a word, but also would like to say about curiosity, kind of level of curiosity on harmonization in academic environment, but also in the USA. Everywhere we had the possibility to discuss. They look at us as a training area where we could practice, have practical work on what's going on. Thank you for organizing this important event. Thank you for advocating of this moment concerned with the international humanitarian law. I look at harmonization as a result of synergy of a few stakeholders. First of all, practices. We talk about investigators, the prosecutors, the judges, as they apply this right and they form this request. In what way it is the most effective to apply some norms to protect rights. Also, such stakeholders are the civil society as they form their request as the violators of international laws, those who are responsible for international crimes, and at the end, the state, and in this case, the Russian Federation, were responsible as for according to the international law and the national law of Ukraine. Also, civil society. These are those citizens who have become victims of this armed, not provoked aggression. And the synergy predicts the verification of those decisions related to the changes in laws. And this verification is possible through academic community and academics who investigate, compare to historical researches. And what results we might receive. Talking about the harmonization of a national law with international law, it started not in 2019, but in 2001, when the new criminal code was adopted and those norms appeared, which turned out to be complicated to comply. They turned out to be complicated for their practice. And in 2001, those norms were dead, as nobody could think that Ukraine will face this situation of aggression, of criminal crimes against humanity. So they didn't perceive it properly. Talking about harmonization, that's why we hear from Mr. Stanislav that Nuremberg model was initiated.
Basing on the Versailles Peace Treaty, so to say the truth, harmonization was already happened, but it was not of high quality. And now we are dealing with its consequences. And the Article 438 of the Criminal Code allows to prosecute people for committing war crimes. Harmonization, to tell the truth, is an ongoing process. Harmonization of national law with international law, because it is connected with the changes in international law. International law is not static, it is changing all the time. And if we speak about the United Nations General Assembly, they have the bill of law draft of crimes against humanity. And if Ukraine wants to take into consideration the consequences of the negotiation process or would like to join the convention, the changes in the national legislation will change, will happen. Also, we can see examples where there are norms of national legislation are in harmonization with international legislation, but still some changes happen. And for example, to speak about Germany, recently there have been changes in the section concerning international crimes. So today we propose a bill which would pull Ukraine to the state of international humanitarian law which currently exists, but it will not finish the process of harmonization. And along with the harmonization, we also use the term implementation of the Roman Statute to the into the national legislation. Implementation, it is not only about changes about in national legislation. Uh, oh, also certain changes in the national legislative system and the national system of justice. So changes into the Article 438 is one of the parts of the puzzle of the huge work to be done, which is connected with the implementation of international legal legislative norm to national uh, legislation. The fact that international law is undergoes development, it's also let's see, let's analyze the Rome Statute. A lot of people see the Rome Statute as an ideal document which foresees the norms and responsibilities for violation of certain norms and international for commitment of international crimes. But after analyzing it, we can see that a lot of crimes and war crimes are international crimes are not foreseen in the Roman Statute, and the Roman Statute fixes uh, the state of international law in 1974, and now currently we have 2026. A lot of changes have happened, and changes in in the legal system, and we have to base on not only on the Roman Statute when we speak about harmonization, but also on other projects. And you can see in our bill the crimes which are not foreseen by the Roman statute, but by other documents of international law. And also, I would like to speak separately about the integral single language of legislation. When we speak about inquiries, international legal assistance, extradition, our documents have to be clearly understood and have to be properly read by our colleagues abroad. They have to be clear, understandable, and In order to make them clear, our material law and national legislation of Ukraine has to respond to international law. And we invite you to read this bill, to express, to share your thought. International working group have not finished their work yet. We continue searching, we continue analysis to propose people of Ukraine qualitative changes to material legislation. Thank you. Here I would like to make a pause. Thank you very much. Yes, we understand that the whole process and passing the bill into the parliament, of course, the Interagency Working Group will have to defend, to protect their position, but on the other hand, they will have to bring corrections into these documents. Yes, there are a lot of things which are not regulated and embraced by international law, for example, cyber crimes. Konstantin, I would like to address to you. On one hand, we are in the state of war. On the other hand, there is a mythology which rose around ratification of Roman statute. And I would like to hear a comment from you. What shouldn't we expect from this law, from this bill? And what it wouldn't break or make worse? And what about the law, this law and Euro integration? Does it correspond to the requirements of the European integration? Thank you, Alexandra. Let me start from the other point. I would like to start, first of all, I would like to point out the leading role of the Prosecutor General office and Mr. Stanislav. And as Sasha and also my colleagues mentioned, this bill, it hasn't been registered yet. I hope it will be registered soon. And if it happens, it will be our sixth attempt to harmonize our Ukrainian legislation with the international legislation. I participated in preparation of this bill, and I can compare the current stage with the year 2016 when I participated at the governmental bill, which was accepted during the first reading of Verkhovna Rada. And at that moment, the General Prosecutor's Office and law enforcement agencies were rather skeptical as to necessary changes in legislation. They didn't believe that changes were necessary. And today, personally to me, it's very pleasant that the situation, I'm very pleased that the situation has changed and law enforcement bodies understand that changes are necessary. And of course, the current legislation does not meet the current requirements and practice. You know, practice, it is the true situation that we have. And then what Sasha mentioned, I would like to point out one important thing, and I'd like to speak generally. First of all, I want to say, and I'm sure that there are not only legal experts here, this bill does not has nothing to do with International Criminal Court. If this bill is accepted, it will be used by Ukrainian judges, Ukrainian courts. It doesn't widen the jurisdiction of International Criminal Code. No way. It will be used in Ukraine. If certain states, as it was claimed these days, want to stop using International Criminal Code. So this document embraces totally different things. we need certain changes. Our country needs certain changes. Another point of mine, during the last years, what I often heard about from politicians, that we don't need to bring changes into Article 438, the article Mr. Stanislav mentioned, which embraces criminal war crimes. Today we have 240,000 and of war crimes committed, and if we bring changes, Mr. Stanislav will have to do a lot of paperwork, but it's not true, because changes into procedural documents um, uh, are necessary during time, when time passes, and when time passes, we have to bring technical changes and rewrite some parts of law, and this bill is written in such a way and designed in such a way that it doesn't give any conditions to stop a person's responsibility or liability, or to restrict a person's liability. It is a risk. The risks are there are no risks. They're nivellated. There are no risks at all. Also, this bill doesn't create any risks of ungrounded criminal liability for Ukrainian citizens. And the last thing I wanted to mention is that, and also my colleagues spoke a lot about the necessity of changes and why are these changes necessary. And in my own understanding, these changes are legally necessary. And why? You can give different explanation and basing on international criminal law as well. In there are a lot of things international criminal law does not mention, but the European integration makes these changes necessary. And it is, first of all, in 2014, Ukraine signed an association agreement, and it had to ratify the Rome Statute of the Criminal Code and to implement the statute, and this brings to changes to national legislation to make it maximally harmonized as to Rome statute, if we speak about the crimes which are in the jurisdiction of ICC. Ukraine started negotiating as to joining the European Union, and the first negotiation cluster with Ukraine was the benchmarks did not mention the harmonization of the legislation of Ukraine with the Roman statute, but the European Union expects from Ukraine to do next steps. On one hand, it can be a full implementation and full harmonization of our internal legal system with the Rome statute, and it makes no sense to wait until these changes in legislation happen, and because it's our duty in front of European Union within the framework of integration process to bring these changes, and to close the first cluster as to entering joining the European Union. It's necessary. These changes are necessary. Thank you. We have a couple of minutes for questions. Please raise your hand who would like to comment something. Our speakers have opportunity to provide comments or in private format. Irina Жданова, Radio Суспільне Ukraine. I have a question. You mentioned that this bill is sent to analysis to Верховна Рада. So which issues will be the most will be discussed, and what will raise arguments, and which proposals will be given? Maybe Stanislav, it's for you. I'm afraid my question will make you disappointed. On one hand, this bill is rather big because we separated once Article 438. We divided it into 5 points, so we increased it. So on my point of view, depending on the focus of attention, issues may raise or it can be legal issues. For example, what Ms. Alina mentioned, decriminalization with passing of time. It is a complicated legal issue, and also some precise spot moments. What I mentioned in my presentation, Article 438.1, war crimes against property, what we speak about uh, when we speak about pooling, and we have it in international code, and we can see that legal experts can ask how to deal with such issues. And summing up, I would like to say that I'm absolutely convinced that this bill objectively doesn't have any controversial or threatening provisions for Ukrainian society in general, or for any representatives of a certain type of professions. You know what I mean? It's a good, well designed law, and it gives us prosecutors to counteract international crimes and war crimes committed by the Russians. But speaking about certain provisions, we are ready for international dialogue and negotiations. And there is no choice between one way and alternative way. We are absolutely sure that we are on the right way. We have been going this way for 10 years. And thank you for your question. And a sudden change of criminal code, do you take into consideration this factor? To tell the truth, I believe that such fundamental change of criminal code as creation of a new criminal code will be a challenge for all members of the professional society of criminal law experts. Mm.
So as for now, I am sure that the very code from 2021 will be applied and has answers, and our task is to improve of what we deal with every day. And I would like to highlight that every day these are new war crimes which were registered according to the old, not good articles. So of course it may cause more questions. If those questions are about if that bill is needed, of course we have proofs that it is needed. It has a practical nature, a legal nature, and Euro integration nature. If you talk lower, of course there are more questions if it's a new things for those who will discuss it, and we will be ready to answer those questions as those people who develop that. So to sum up, we have the process which was started 25 years ago. The last 10 years, just intensive proposals. I'm talking about final phase. We have such a will as a civil society, academic community are interested to punish those aggressors who torture Ukraine for the 12 years. The war which started 300 years ago. Thank you very much for being with us. And we are open for communication to answer more questions in